Hello and welcome. We are back talking again tonight about the Constitution and our Supreme Court. And my guests from last week are back. I'll introduce them to you left to right. My first guest is Heidi Kitrosser, and she is at the University of Minnesota Law School. She's a Yale Law School grad, did her clerking with the U.S. Court of Appeals judge with, what judge were you with?
Judge Judith Rogers on the U.S. Court of
right.
Appeals for the D.C. Circuit.
Right, and as I mentioned last week, that court is considered one of our top, probably the second most important court in the country, so must have been a very, very good experience.
It was a terrific year.
Heidi, also I want to mention, before I introduce our second guest, is the author of a new book, came out in 2015, about the Constitution called Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution. And we will have a chance to kind of zoom in and focus on that more later on. My second guest is Jill Hasday, and Jill is a distinguished McKnight University Professor of Law at the law school here at Minnesota. Also came out of Yale Law School. Also an author, is writing a second book, but wrote a book called Family Law Reimagined. So welcome back, both of you.
Thank you.
Well, as I said, we're going to look at some big cases. I think we're going to first look at the Texas abortion case, which is one that Jill has studied a lot. It's a big, big case. It's been since 1992 that the Supreme Court looked at abortion in this kind of in-depth way. What can you just tell us, kind of in a nutshell first, Jill, about this case and why it's important?
Okay. So Texas passed a law that requires abortion providers basically to conduct all abortions in essentially hospital-style operating rooms, even if it's a non-surgical abortion. And they also required that any doctor performing an abortion have admitting privileges in a local hospital. The hospital operating rooms is just enormously expensive, and a lot of the clinics don't have the money. Even more tricky is the requirement that the doctors have admitting privileges, because most hospitals in Texas, which in general doesn't have a culture too friendly to abortion, refuse to give admitting privileges to doctors. Usually what happens though, of course, in the rare case when a woman needs to go to the hospital because there's some complication, which is rare, of course the hospital just takes her. You don't have to be an admitting doctor to be able to get your patient in the hospital. The bottom line is that it seems when the law fully goes into effect, there'll only be 6 abortion clinics that are able to operate in Texas, which is an enormous state. So the case,
because of the fact that
they can't comply with these rules.
Right, they're not big enough in terms of the actual facility. The doctors can't
get admitting standards, right? Mm-hmm. And the few that remain are disproportionately in the wealthier areas. So the poor areas around El Paso, there's not going to be any, not going to be any clinics.
So women will be forced to either travel a great distance, go to Mexico.
Right, and many of the women seeking abortions, many, also, especially in these poorer parts, have limited resources. They might not have a car. They might not have the freedom to leave their work for a 12-hour drive into the neighboring state. So the Supreme Court has said in a case from 1992 that abortion restrictions are unconstitutional if they impose what's called an undue burden on women's access to abortion. So the question in this case really is, does this law impose an undue burden on women's access to abortion?
Now, when Justice Scalia died recently, and we want to kind of bring in how his death impacts big cases, had he not died, he would have wanted to be restrictive.
Right. Justice Scalia never met a restriction on abortion he didn't like. So he was clearly a vote. Okay. He was clearly a vote to uphold.
That's a very strong statement, but that's
true though.
That's true.
And Kennedy, who was the swing vote when Scalia was there, also has grown increasingly hostile to abortion over time. at least in my view. So with the absence of Scalia, now it looks like there's only 4 votes for upholding the law. So this is one of the laws that.
So we're 4-4 at this point. And when we have only 8 justices and it's a tie, then it goes back to the lower court ruling, correct?
Right, so it's automatically upheld, but it's not considered a binding precedent. So the lower court in Texas, on other areas of the country, so the lower court in Texas had upheld the law, so the law would remain in place in Texas, but it wouldn't set a precedent for other areas of the country. They wouldn't be obliged to allow similar laws. Other courts of appeals could come to different decisions, and in all likelihood, depending on who was appointed to the 9th spot on the Supreme Court, they would be later challenges and attempts to
So
relitigate.
not binding is an important thing to remember at this point.
I'm sorry?
The fact that it would not be binding is important to remember.
Right, it would be binding. The Fifth Circuit's ruling would control in the Fifth Circuit, which is Texas and
that
surrounding
part of
states, but
Texas.
not the rest of the
country. Are people flocking to Texas to protest? What's the scene like there?
There have been widespread protests, but not only in Texas, more nationally. I mean, one of the things that's, for instance, one of the movements, it's not in terms of a visible protest, but there are organizations, they'll help women, basically give them grants so they can travel. Even now when the law hasn't fully gone into effect, the waiting periods in existing abortion clinics in Texas are very long. And one of the ironies of the law is the theoretical purpose of the law is to protect women's health, but in actual fact, it often endangers women's health by making it harder to have access to abortion. Abortion is safer the earlier you could do it.
Correct.
So if you have to wait because you have to get the money together to travel, or you're just waiting for your appointment for a few weeks, that itself increases the health risks. So there is a whole feminist network providing grants to help women leave the state for abortions. Very reminiscent, by the way, of the feminist networks that existed before Roe v. Wade.
What do you think, as you're not studying it to the degree Jill has been, I understand, but weigh in here.
Yeah, so several things. First of all, I think Jill explained it perfectly. So that's absolutely right in terms of what's at stake and what the case is about. I guess a few things I would add are, one, going back to, as Jill told us, the governing standard, going back to the 1992 case, Casey is the name of the case, that established the undue burden standard, right? Saying that to be constitutional, the law a law is unconstitutional if it imposes an undue burden. It is really striking how, in theory, that may sound kind of straightforward. Okay, is it an undue burden? The court has elaborated a bit more to say, what does that mean? It means it imposes a substantial obstacle in intent and effect. Theoretically, that sounds sort of clean. Gets really complicated when the court has to actually apply that to specific laws, right? And so, as Jill alluded to, in addition to the current case, the pending case, as well as the lower court case regarding Texas. There have been a host of previous cases, certainly in lower courts, but also at the Supreme Court level, involving other obstacles, raising questions of, do these impose undue burdens? And in the past, in Casey itself in 1992, one of the notable aspects of that case was that the Supreme Court upheld, I believe it was a 24-hour waiting period. Jill was, referring to waiting periods a moment ago, essentially in the face of arguments by the women who were challenging the 24-hour waiting period, and they argued along the lines that Jill was talking about with the distance, saying, well, this is really problematic because, what about women who don't have cars, who can't get the day off from work, who are potentially at risk of being physically or emotionally coerced by partners or by family members to whom they can't reveal that they're going out of town for a day or two to get an abortion. And the court there essentially said, we haven't been persuaded that this presents an undue burden. Again, though, this is a slightly different court composition now that Justice Scalia is no longer on the court. So it is interesting to see if the court would, view the question of undue burden and its application somewhat differently. One other thing I think worth noting, Jill had mentioned that there's a certain irony in that, Texas's ostensible justification for this particular law is to make women safer. Could have the intent, obviously, of forcing abortions underground, making them unsafe. I recall that reading about the oral argument in this Texas case, and there was an interesting moment that spoke to one of the ways in which the law could make women less safe, at least as safe as defined by Texas. So as I understand it, Texas has said, well, you have to have these requirements, you have to have admitting privileges, you have to have hospital type rooms, otherwise the women are unsafe. And at one point—
Which in a way sounds very humane, doesn't it?
Absolutely, absolutely. And my recollection is, though, at oral argument, I guess it was the Texas SG or whoever was, making this aspect of the argument on behalf of Texas, was getting hit with a number of questions from, I believe in particular, Justices Sotomayor and Kagan and Ginsburg, asking notably the three women on the court, really trying to get at the heart of whether this was a health necessity. And they were pushing them on this point that, well, there are going to be so few options. Won't this cause women to go to illegal back alley abortions? And the person representing Texas, as I understand it, said, well, there are also other states. They could go to New Mexico, which, of course, and I believe one of the justices actually immediately made the point that, well, wait a minute, doesn't that suggest that perhaps you're not really that concerned that, all of these onerous Texas requirements be met, if you're very sanguine about saying, well, they can go to a neighboring state that doesn't have these requirements.
We're going to shift gears now and kind of put you in the driver's seat, Heidi, and talk about Citizens United, 2008 case? 2010 case. It was a 5-4 case. And now with Justice Scalia's death and all the wish to revisit it, what can you tell us, first of all, about the case and just kind of very generic, explain it to those who might not know about it?
Yeah, absolutely. So at issue, I'll just say a little bit about the specific facts and then, more broadly, the relevance. So specifically at issue there was a law that essentially prohibited corporations as well as unions. The analysis in the case was almost entirely about corporate speech, but the law at issue did involve unions as well, prohibited them from engaging in what the law referred to as electioneering communications. And this essentially was making what are called independent expenditures on behalf of or in some way related to a candidate in some period of time before a federal election. And the reason they use terms like electioneering communication and expenditures is to sort of make clear what the law was not about. The law actually was not about campaign contributions. It wasn't about whether corporations or labor unions could donate money directly to a particular candidate's war chest, so to speak. Rather, it was about whether they could make independent expenditures, which essentially means spend money to themselves, independently finance ads saying, I love Mitt Romney, right? Or vote for Mitt Romney, or vote for Hillary Clinton, or what have you.
So there's some public misconception, isn't there, about the original language?
To some degree, yeah. And there's a long and complicated history in campaign finance law, but very roughly speaking, going back to the mid-1970s, when we had the first series of major First Amendment cases about campaign finance laws, the Supreme Court actually has drawn some distinction between campaign contributions and these so-called independent expenditures. And essentially what they've said, going back to a 1974 case called Buckley v. Vallejo, which was their first major statement about campaign finance, essentially they've said, look, both kinds of laws raise big concerns under the First Amendment. So really the way to Citizens United was paved way back in the 1970s. However, they've also said that they're more concerned about expenditures than contributions for a number of reasons, but one reason is that they took the view back in Buckley, and they continue to maintain it, that an individual or an entity's speech is more directly infringed when they're prevented from making a so-called independent expenditure, because they view that as more akin to forming one's own speech as opposed to a campaign contribution, which they say is a very important way of expressing oneself, but they say it's a little bit less expressive. Than actually financing the ad of your choosing, for example. So there were restrictions on the ability for Citizens United, on the ability of corporations and unions to fund these electioneering communications, and the Supreme Court struck it down in this landmark Citizens United case. And they said a number of things. I mean, the core holding was simply that they struck down this law in terms of the upshot. Among the important things that they said, though, well, perhaps the most important thing that they said was that they said, first of all, corporate speech, entity speech, union speech, is protected, just like the speech of individuals, including when it takes the form of spending money to finance communications. Perhaps even more important, and this is a less discussed aspect of the case, was the fact that the Supreme Court said it's not a valid government interest for the government to say, we're concerned that corporations or other entities like unions are spending too much money to finance speech. We think that creates kind of a distasteful atmosphere. We think that might make politics seem dirty. Essentially, the court said, that's not valid. That's actually not a legitimate government interest, because that sounds a little too much like suppressing speech for its own sake. That sounds a little too much like saying there's too much speech out there. There's too much speech being financed. And so the court clarified that when they say there's a legitimate government interest in stemming the tide of corruption, they really mean something very narrow. So essentially they were saying, look, it's one thing for the government to pass laws saying we want to keep bribery, quid pro quo deals out of campaign finance. That's legitimate for the government to do.
And we all like that idea, don't we?
Exactly,
Right.
exactly.
Right.
But they said, it's this broader interest in generally trying to take money out of politics, that they said is not legitimate, and that actually has significant practical effects. So, yes.
Do you think that the justices themselves, the country as a whole, have people been surprised at how the ruling did affect our country, though, in terms of campaigning and the broader issues?
Well, I think that there is a consensus that it has made a difference, because what it did essentially was invalidate the ability of governments to, I say governments because federal and state as well, to prevent corporations or unions from spending money to finance their own ads or to create and help finance their own PACs that create ads. It prevents government from saying, hey, just because you're a corporation, you can't do that, right? Which obviously does open the coffers. Additionally, there have been some other rulings that followed in the wake of Citizens United that kind of kept the ball rolling further. So, for example, in 2014, a case involving the FEC, the Federal Election Commission, and there the court struck down aggregate limits, and this involved campaign contributions, right? So, so your ability to donate to, let's say, a candidate's war chest. It didn't question. The case did not pose the issue of whether the government could continue to limit the total amount we can give to any one candidate. However, it struck down the ability of the government to say, you as an individual cannot give more than some aggregate amount to all candidates total. So they struck that down based partly on this narrow definition of corruption. They essentially said, well, if corruption means something relatively narrow, it means we don't want you to effectively bribe a public official, well, then we don't have to worry about aggregate limits. As long as the amount you can give any one person is limited enough, you can give to as many candidates as you'd like. You can spend as much as you'd like in the aggregate, as long as we limit it candidate by candidate.
Now, that was a 5-4 decision.
Yes.
What do you anticipate if it comes up now? What will it, how is it looking in terms of the breakdown of voting now?
I think this is one of the many subject areas where Justice Scalia's death really could have a big impact. Citizens United, the 2014 case I just referred to, some other similar campaign finance cases were 5-4 cases with Justice Scalia in the majority. And so now, unless one justice drastically changes their orientation, we have a 4-4 split. So
and they will be looking at this in the next, when is it up for?
Well, there's not a particular case pending right now that sort of re-raises these types of questions, but it's only a matter of time, given how prevalent campaign finance questions are.
It may not be that it would be considered until we have the next justice.
Yeah, that's
likely.
Probably the case.
Okay.
Yeah.
Just your brief comment, Jill.
Well, one is to say, I don't think it's surprising that Citizens United, most Supreme Court cases don't really attract a lot of popular attention. You know, they're in the New York Times or the national newspapers for a day or two and then they fade away. Mm-hmm. It's interesting that Citizens United has continued to be a major subject of political dispute. And I think in part it's because it's an era of a lot of concern about income inequality, a lot of evidence that income inequality is becoming more severe. And Citizens United taps into these fears that if money is speech, people with more money get to talk more. And I think that that's one reason why there's just so much concern about this, paired with the idea that the Supreme Court may have too narrow a conception of what corruption looks like. It's interesting that they're, in general, more sympathetic to the idea of restrictions on campaign donations in judicial elections than in other elections. And a cynic might suggest it's because they take the integrity of the judiciary more seriously than the integrity of legislatures. They say, well, that's just horse trading anyway. So there's, in my view, there's a slight tension there. Because they seem much more receptive to appearance of corruption arguments when it's a judge potentially being corrupted.
Interesting, yeah, I hadn't thought of that. Well, one last word, and then we want to talk about your book. We've only got a few minutes left.
I think that is a nice and very apt contrast with the couple of judicial cases that have come up. And indeed, in the 2014 political campaign finance case that I mentioned, the majority opinion responded to the dissenting argument that, we should really take a broader view of corruption. It's problematic when somebody is trying to seek special access, for example, and the majority said, special access, well, that's just how legislation works. That's the healthy political system, whereas they do strike a very different tone in the cases about judicial elections.
Well, I'd love to ask you about some other cases, but we are out of time. I do want to talk a minute about your book, though. Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution. Tell us, Heidi, for those who didn't see the last program, kind of what your main intent was in doing the big job of writing this book, which we talked about. Writing a book is hard work.
Absolutely, yes, and thank you for asking about it. So I focus predominantly in the book on what I call the constitutional law of government secrecy, and what does that mean? It means a couple of things. So partly I'm trying to educate the reader, and this really could go from the interested layperson, to the law student, to the undergrad, all the way really to the constitutional lawyer who may just not be, zeroed in on this particular area, to educate them about what what theories of presidential power have had influence, not just in the courts, but in the executive branch, in the legislature, in public discourse, to break down what those theories are and to explain how they've contributed to, in many ways, sort of the rise and the entrenchment of presidential power, and specifically as it relates to the ability of the executive branch to keep secrets. So part of what I do in the book is explain how executive secret-keeping power has been facilitated and justified through constitutional theories that have had influence across all three branches and in public discourse. And I also make a series of arguments about why I think those theories of presidential power are wrong, and wrong in part because of the influence they have in justifying excessive government secrecy.
This is certainly a topic right now in our country that is very hot. When you started, was it as topical as it is today?
It was.
Were you ahead of the curve? Or?
It was. Well, when I first started thinking about the book, I started thinking about it during the Bush administration. And, of course, there were a number of now well-known instances of what were sometimes referred to as secret law programs that were entirely secret and that conflicted with public statutory law until they were ultimately leaked to the press years later. High-profile instances of the government asserting what's called the state secrets privilege to keep litigation out of the courts. That was my initial set of things that inspired me. But that said, it's been very interesting to see the way in which a lot of those trends really have continued, in some ways exacerbated, in some ways maybe pulled back a little bit, but in other ways perhaps even strengthened in the current administration.
With more public awareness, I think, now than ever.
Yes and no. I think that people became very, very alert during the Bush administration about issues of presidential power and secrecy. I think in some ways the Obama administration has been somewhat more disarming because the tone of the administration is much more friendly to the rule of law.
Quite different.
And so I think there's been a little less pushback.
Well, you'll have to read the book to get some of the nuances here. This is great to have you talk about it a bit, though. If you're interested in learning more about this book or how to access it, you can go to the link we're going to put up, the University of Chicago Law School Publishing House. So check that out. Well, thank you both so much for coming down. And
thanks for having us.
It's been fascinating listening, learning, getting to ask questions. I think all of us in our country right now are really zooming in terms of our interest on the Constitution and on the Supreme Court. So it's been a privilege to get to talk with you both. So thanks again for coming down.
Thank you very much.
Thank you both. I'll be back again next week. Until then, have a good week.